Hello, dear friends. Welcome back in our YouTube channel of official YouTube channel of Indus Lex. Today, again, we are going to continue our lecture on constitutional law. In part first, we already dealt with preamble of the Constitution of India, in which we see that the preamble of the Constitution of India start from the word "we," meaning thereby the Constitution of India has derived its authority from the word "we." And then we see the five key feature of Indian state, which also mentioned in the preamble of India, that we, the people of India, trying to constitute India into sovereign, socialist, secular, democratic, and republic. And then preamble talks about securing some certain rights of the citizen, such as justice, liberty, equality of opportunity and status, and fraternity, unity, and integrity of India. And then we move on part one of the Constitution of India. From Article 1 to Article 4 is the Constitution of India, which deals with union and its territories. Article 1 says India, that is Bharat, and then Article 2 makes power or a provision for amendment, addition of particular territories in union state, and then Article 3 also makes provision that the parliament has power to abrogate, abridge, or separate two states and form another state. Further, Article 4 also prescribes the procedure of amendment in the first schedule and the fourth schedule, because it depends upon first schedule is the schedule in which the territorial boundaries of each state is mentioned, and fourth schedule in which from that particular territory how many parliamentary seat is from that territory is mentioned. And when there is some change by addition or subtraction, then definitely there is change in first schedule and in fourth schedule. To properly channelize this amendment, a separate procedure apart from Article 368, which provides power to amend the constitution. Article 4 provides provision in itself in the amendment of first schedule and the fourth schedule. And then after we move on the part 2 of the Constitution of India, in which Article 5 to 12 the deal with the citizenship. Article 5 to 10, we can say, all are relating to the citizenship at the time of commencement of the constitution. And Article 11, which is an important article, in which it is said that whatever mentioned, nothing is notwithstanding anything mentioned in Article 5 to 10 cannot abrogate the power of parliament to make law on the citizenship, meaning thereby in today's time the law making law for the purpose of governing the citizenship or nationality of this nation, parliament has power, and parliament has power to make law relating to the citizenship. And then a very important chapter, that is a part third of the Constitution of India, is a fundamental right chapter. Fundamental right chapter is dealing with certain rights which guaranteed under the Constitution of India from Article 14 to 35. Part 1 describes the territorial boundaries of the nation. Part 2 describes the citizenship, who will be the citizen of this nation. And then part 3 guarantees certain rights. Before guaranteeing the certain right, in Article 12, Constitution of India defines the word state, because in common parlance, whatever right guaranteed under the Constitution in the part third chapter from Article 14 to 35 is right against the state, meaning thereby state will not make any law or do anything contrary or inconsistent with whatever mentioned in Article 14 to 35. Therefore, the word state is necessary to be defined, and our constitution basically define state in a form of, in a very general form, such as it says the government of union, that the state government, local authorities are state. And then it also says other authorities. In other authorities, those institution will come which has any deep or pervasive control, financial or monetary control, or administrative level control of government or a state. Then that particular authority will also come in the ambit of other authorities, and thus in the contour of state. Then further, article 13 says that whatever law is enforced before, at the time of commencement, they will be null and void at the extent of the inconsistencies with this part, meaning thereby whatever law was in force at the time of the commencement of the constitution, if any provision of that laws is inconsistent with the rights mentioned in article 14 to 35, they will be inoperative, null and void, at null and void, because constitution says that article 13, it also define what is law. It says any rule, regulation, ordinance is law, including custom. And further, article 13 says that state will not make any law which is inconsistent with fundamental rights guaranteed under article 14 to 35. Then we see, then article 14 to article 18, that right to equality. And then we see article 19 to 22, right to freedom. In article 19 there are certain rights, freedom of certain rights. Article 20 is relating to criminal law. It save any person from jeopardy, that is, a person cannot be put at trial twice for a particular offense. Article 21 is reservoir of the fundamental right. It talk about personal liberty, or life and protection of personal liberty cannot be curtailed, otherwise procedure established by law. After Maneka Gandhi versus Union of India, the procedure established by law is interpreted as due process of law, which mentioned in American Constitution. Then again, Article 22, which talk about that nobody can be illegally detained more than 24 hours, that the any police officer, if arrested anybody or detained anybody, he must be produced before nearest magistrate or jurisdictional magistrate within 24 hours. Then there is article 23 and article 24, right against exploitation. Article 23 barred forced labor. Article 24 barred child labor. Then Article 25, 26, 27, 28. These right is right to freedom of religion, cultural and educational rights given in Article 29 to 30. And then Article 31 is repealed. Article 32, right to constitutional remedies. It is a very important article, because what the article 32 says, article 32 open the door of Supreme Court, honorable Supreme Court, to every citizen in the case of violation of their fundamental rights. Dr. B.R. Ambedkar says it is a soul of the Constitution of India because it creates a, a very fine fundamental right that a citizen can approach directly to the Honorable Supreme Court in the case of violation of his or her fundamental rights. Then, after Article 32 is a fundamental right in itself, and it says if there is any violation of the fundamental rights mentioned or guaranteed under Part 3rd of this Constitution of India, a citizen can approach the Honorable Supreme Court of India. And after Part 3rd, Part 4th is Directive Principles of State Policy, DPSP. It is a direction to state which type of law state would be make or pass in the parliament or legislative assembly. Article 36 is a definition. It says that the definition of state is the same as mentioned in Article 12. Article 37 is the application of principle contained in the part directive principle and fundamental rights. Now, Article 38 is an important article which is based on socialist state, that is state to secure social order for the promotion of welfare of the people, meaning thereby whatever law will make by the lawmaker is directed by the DPSP provisions of the Constitution of India, and as per the Article 38 it says that lawmakers makes law by which welfare of the people can be done. Then Article 39, certain principle of policy to be followed by state. And one thing is important to note that in the violation of Article 14 to 35, you may knock the door of Honorable Supreme Court under Article 32 because it is fundamental right in itself that in the case of violation of fundamental right, you can approach the Honorable Supreme Court. But in the same manner, you can't enforce whatever mentioned in the DPSP because it is only directive in nature and can't be enforced in the court. Article 39A, equal justice and free legal aid, meaning thereby again Constitution of India imposed duty on state that state will make such law by which equal justice can be promoted and free legal aid can be given to the litigant. Article 14, based on Gandhian principle that the organization of village panchayat, and we will see in later provisions of the Constitution of India that in the regime of Rajiv Gandhi government, a detailed arrangement of panchayat election and three-tier government is set up in the India. Article 41 is another modern type of directive which says right to work, right to education, right to public assistance in certain cases. Further, Article 42 says provision for just and human condition of work and maternity relief. And Maternity Relief Act is passed by the Parliament, meaning thereby there is a direction in the Constitution of India, and on the basis of that direction, Parliament or a lawmaker pass laws to implement the DPSP, but you cannot claim as a right or you can't enforce the DPSP provision in the court. Article 43 talks about equal wages. Article 43A talk about participation of worker in management of industries. Article 43B talk about promotion of cooperative societies. And again, Article 44, which is very controversial article, but at the time of making the constitution makers put this article, and in the part fourth, that is DPSP, that the law will be make on this aspect. And Article 4 is uniform civil code for the citizens, meaning thereby the Constitution of India makes provision in Article 44 that the state will make law by which a uniform civil code can be implemented in the country. Further provision for early childhood care and education to children below the age of 6 years, again put in DPSP. 46, Article 46 talk about promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker section. Section 47, duty of state to raise the level of nutrition and the standard of living to improve public health. Article 48, organization of agriculture and animal husbandry. Again, this provision is based on Gandhian principle. If we talk about Article 38 to Article 51, they can be classified on basis of three broad principles. That is a liberal principle, or we can say the Nehruian principle, we can say the communist principle, or a welfare state principle, or a socialist principle, or we can say or categorize these articles on the basis of Gandhian principles. And when we talk about the separation of judiciary from executive, it is based on liberal principle. As we know, in our country, legislature and the government legislature and the government is overlapping with each other, and other wing of the state, that is judiciary, is also depend on the executive of the state to implement and enforce its order. But here in Article 50, separation of judiciary from executive, meaning thereby state will make such laws by which separation of judiciary and executive can be done. Article 49 talks about protection of monuments and places and objects of national importance. Article 48A talks about protection and improvement of environment and safeguarding of forests and wildlife. Article 51 talks about promotion of international peace and securities. And then further, 51A deals with fundamental duties. It is also inserted by the 44th Amendment. 51A fundamental duties, in which 11 fundamental duties is mentioned. Fundamental duties is also not a such type of binding nature, but if you can't follow your duties, it not come with some type of cost or a penal in nature. It is more moral duties of every citizen that they should follow these fundamental duties of the country. It is A to K, means 11. What is this? Every citizen to abide by the constitution and respect its ideal and institution, the national flag and national anthem. It is a duty of every citizen that they should respect the constitution and its ideals. Whatever principle mentioned, on what ideas our foundation of our constitution is held on, every citizen has to respect it. Then again we have to move on preamble, where it is mentioned that justice, liberty, fraternity, unity and integrity of the nation. It also says to cherish and follow the noble ideas which inspired our national struggle for freedom. What are those novel areas, novel ideas on which our national movement of freedom struggle is based on? We have to respect them. To uphold and protect the sovereignty, unity, and integrity of India. It is duty of every citizen of India that he must uphold the sovereignty, integrity, and unity of India. To defend the country and render national services when called upon do so. It is again the duty of every citizen that he must be ready to defend our country whenever it is called, whenever it is required. Total 11 fundamental duties, and it is amended in the 42nd amendment. It is inserted in the constitution, that article 51A in 42nd amendment, not in 44th. 42nd amendment of constitution in year 1976, it is added 51AK, which is added in 86th amendment, that is the 11th. Who is a parent or guardian to provide opportunity for education to his child, or as the case may be, ward between the age of 6 and 14 years. 6 to 14 years. Every parent has duties as per the provision of Article 51A, subclause K, after the constitutional amendment 86th amendment 2002, that parents will provide opportunity to their children who is between the age of 6 to 14. So all this is about preamble. Part 1, Union and its territories. Part 2, citizenship. Part 3, fundamental rights. Part 4, directive principle of state policy. And Part 4A, fundamental duties. In the next part, we will see which provision we have to understand elaborately from the part 5th, which start from the union, and it also describes firstly executive, and then it talks about parliament, and in last it talk about judiciary. That is all about part 5th. In part 5th, when we talk about chapter 1 executive, it starts from section 2, the president of India, that the India shall have president, and who is a supreme commander of army. Article 53 says executive power of union is vested in the president, and who is the executive head of the government. Election 54 talks about election of president, how the election of president will be held, what will be the eligibility of the president, who can contest the election of president, what is the criteria for being nominated for president election. Article 55 deals with manner of election of president. Article 56 talks about term of office of president. Article 57 talks about eligibility for re-election. Article 58 talks about qualification for election as a president. Article 73, extent of executive power of the union. And then Article 74, council of minister. Council of minister to aid and advise of president. Whatever the council of minister will work on the basis of aid and advice of the president. Other provisions relating to prime minister, other minister, removal of minister, collective responsibility, dissolution of house, membership of parliament, salaries of minister, all deals in Article 75. Then it also talks about Attorney General of India in Article 76. Parliament, Chapter 2, deals in Article 79, that the Constitution of Parliament. Article 80, composition of Council of States. Meaning thereby in parliament is made of Lok Sabha, Rajya Sabha and the president. And in the same manner, it talks about disqualification of members, then legislative procedure in financial matters, then general procedure, legislative power of president. President has all three type of power, that is executive power, legislative power and judicial power. He also has. We talk about legislative power of the president, article 123, and then chapter 4 start from article 124 with establishment and constitution of honorable supreme court. It talks about all the jurisdiction, detailed jurisdiction, that the seat of Supreme Court, Article 131, original jurisdiction of Supreme Court, Article 132, appellate jurisdiction of Supreme Court in appeal from high courts in certain cases, 133, appellate jurisdiction of Supreme Court in appeal from high court in regard to civil matters. And in the same manner, parts chapter 5th, the Comptroller and Auditor General of India, article 148 to 151. Part 6 start from article 152, that is the states, and the same story and the theory which is at union level would be repeat at the state level. And after this chapter, the seventh part is repealed by the Seventh Amendment 1956. Then part 8 is Union Territories. Administration of Union Territories defined in Article 239, meaning thereby there is no part 7. After part 5th, Union Government, part 6 State Union, and part 6 the state, part 7 is Union Territories, part 7 is repealed in year 1956, and part 9 what we see that the Gandhian principal organization of Panchayati Raj, part 9 the Panchayat, part 9A the municipalities, part 9B the cooperative societies. In DPSP we have seen that state will make laws to upliftment and progress of cooperative societies. Part 10 deal with the tribal and schedule and tribal areas. Part 11 is important, which discuss the relationship between the union and the state, and this chapter is very interesting because the relation between the union and the state is very much important when we see that in the era of goods and services taxes, state has very limited source of its own income, and majority of time state is depend upon the central government for their funds. So distribution of legislative power, distribution of executive power, dispute relating to water, all disputes is deals in part 3rd, article 245 to 263. Part 12, part 11 relation between union and the state, and part 12 finance, property, contract and suits. This chapter is relating to taxes, distribution of revenue between the union and states, that is article 264 to article 300. Then again the fundamental right which is mentioned in article 31 and also in article 19, that fundamental right is right to property, which is repealed, and now it makes in change into the constitutional right, that is right to property, meaning thereby right to property is a constitutional right, not the fundamental right. There are certain type of right. If the right evolved from a statute, that is criminal procedure code or civil procedure code or any other statute, then that right called statutory right. On in the violation of statutory right, you may invoke the article 2 to 6 against the authorities. But in a case there is a violation of fundamental rights, you may invoke Article 32. In case of violation of constitutional right, that the right mentioned in other different parts of the constitution is a constitutional right, such as Article 300A, person not to be deprived of property save by authority of law, that is a constitutional right and it can be protected by invoking Article 226 of the Honorable High Court, not by invoking Article 32 of the Honorable Supreme Court, because you may invoke Article 32 jurisdiction only in the cases in the violation of fundamental rights. Then part 13 relate with trade, commerce, intercourse within the territory of India. Part 14 deals with service under the union and state. Here the Union Public Service Commission, State Public Service Commission will be dealt with. Then further 14A talks about tribunal. Part 15 talk about election, Article 324 to Article 329A. Part 16 deals with special provisions relating to certain cases, that is reservation of seat for scheduled caste and scheduled tribe in the House of the People, Article 330, and it would go on to Article 342. Then again in Part 17, official language of the Union given in Article 343. Article 345 talks about the official language of the state, and then a special directives is there. Language of the Honorable Supreme Court and High Courts is given in Article 348 and 349. Chapter 18 or Part 18 is a very important part, that is emergency provision. Proclamation of emergency, Article 352. Provision in case of failure of constitutional machinery in state, that Article 356. Article 360 relates to provision as to financial emergency, meaning thereby there is three type of emergency. One is commenced from the proclamation of emergency. Second one, when constitutional machinery is not properly working, and third one is financial emergency. Part 19 is a miscellaneous part, such as Article 361, protection of president and governor and Raj Pramukh from certain liability, that is Article 361. Part 20, Article 368, amendment of the Constitution. Power of Parliament to amend the Constitution and procedure thereof is given under Article 368. Part 21 talks about temporary, transitional and special provision, that is Article 369 to Article 392, and Article 370 is one of them. Part 22 talk about short title commencement, authoritative text in Hindi and repeals. And in this manner, 22 part 395 articles is there in the Indian Constitution. Then it deals with first schedule, that is territories of state and union territories. Second schedule deals with provision as the president and governor state, provision as to minister for the union and for the state in part A, part B. Third schedule talks about forms and oath or affirmation. Fourth schedule, allocation of seat in the Council of States in the Rajya Sabha. Provision as to administration and control of the scheduled areas and scheduled tribe given in fifth schedule. Sixth schedule related to administration of tribal areas, state of Assam, Meghalaya, Tripura and Mizoram. Seventh schedule talks about subject list over which government has authority to make law, that is three list in seventh schedule: union list, state list and concurrent list. Union list are those lists on which the union government can make law. State list are those lists on which the state government can make laws, and concurrent list is that list of those subject matter on which union government and state government both can make laws. But if there is consistencies between the law made by union government or state government, or a law made by the state government, then on the same subject which is mentioned in concurrent list, union government passed some law, then the law made by the union government is prevail over the law made by the state government. Then eighth schedule deal with the language. In eighth schedule, the official language of the India is mentioned. Ninth schedule is that schedule in which the court has no power to do judicial review to the extent that it doesn't violate the basic structure of the Constitution of India. 10th schedule deals with the provisions to disqualification on ground of defection. This schedule is added by the government of Rajiv Gandhi. It is anti-defection laws. Relating to anti-defection laws, we see in our legislature many time member of parliament or member of legislature do defects from their own party on whom symbol they won the election. To prevent such type of defects in our democracy, these schedule is added, that is 10th schedule, and then 11th and 12th schedule is in the constitution. That is all about the brief introduction of the Constitution of India. We will continue this series and talks about a very proper nuances what the Constitution is in its sense, and what in the practical difficulties arises when we talk, when we deal with at the administration level, that the administration of nation. Because as we know, the Constitution is a tool for administration, but our constitution is not only the tool, but it's guaranteed the right of every citizen. It also makes some instrument by which the state can smoothly run. It based on the principle of check and balances, because it is our constitution which describe the all phenomena relating to high court, supreme court, public service, and election commission. So for today, thank you to join us. We will meet soon.